Hello, everybody. My name's Dale Frech. I'm the Safety Director with the Association of County Commissioners of Oklahoma, and I brought Charlie Plumb with McAfee Taft in, and we've been getting a lot of questions about the new rules under the Fair Labor Standards Act, and we're going to see if we can't get Charlie to kind of help enlighten us on what they really mean and how they're going to impact us. This is Charlie Plumb.
Dale, thank you so much, and thank you for inviting me. So we're going to talk this morning a little bit about the new changes to the Department of Labor's regulations when it comes to white-collar exemptions. And that is, there are three white-collar exemptions, main ones. They're the executive exemption, the administrative exemption, and the professional exemption. And they really apply to certain white-collar jobs that employers have. And if you fall into those exemptions or one of those exemptions, you're not required to pay overtime. And the way you decide whether you have some people that fall into one of those white-collar exemptions that are not required to be paid overtime is, first of all, they have to meet a certain duties test, okay? And with these white-collar exemptions, the duties need to be kind of executive or office, certain supervision requirements, certain educational requirements. So they have to meet a duties test. Number two, they have to be paid by salary. They can't be paid hourly to be under these exemptions. And number three, that weekly salary has to meet a certain minimum weekly amount, okay? To qualify and not be required to pay those employees, if they fall in those exemptions, overtime. All right, so the significance of these July 1, 2024 changes that the Department of Labor made is employees who were treated as exempt and entitled to overtime, or in the case with the counties, comp time, if they work more than 40, were not entitled to that. What we're finding is, effective July 1, 2024, in order to keep that exempt status, so you're not entitled to overtime or not entitled to compensatory time, you still must meet the duties test. You still must pay these people a salary. But the Department of Labor increased the weekly salary minimum you must hit. July 1, 2024, that minimum weekly salary amount increased from $684 a week to $844 a week. It's going to get even higher January 1. It goes over $1,100. So what's happening to employers, including some counties, if you have employees you've classified as exempt under these white-collar exemptions, executive, administrative, or professional, you may have them not entitled to overtime or not entitled to compensatory time because they meet the duties requirements, the duties test. You do pay them a salary, but now what's happened is the minimum weekly salary has increased, and employees you have been classifying exempt and not entitled to comp time or overtime may not meet that new increase of weekly salary. And your choices there are, if you want to keep those employees exempt from overtime and compensatory time, you have a couple of choices. You can increase their weekly salary to meet these new minimums, the $844 a week that went into effect July 1, and the over $1,100 a week limit that goes into effect in January. Or if you're not going to do that as an employer, you reclassify them as non-exempt. They no longer are going to meet those exemption requirements with these higher salary amounts. You need to pay them hourly, start tracking their hours, because if they work in excess of 40, they're going to be entitled under these new regulations potentially for comp time or overtime.
Okay, Charlie, with these new requirements, the salary portion of that equation, the old standard prior to July 1, these employees had to make $35,568 per year. After July 1, they were increased to $43,888, and after January 1, it's going to be increased again to $58,656 before they meet the salary side of that equation to be considered an exempt employee. One of the questions I often get is, we have many elected officials around the state that don't make that amount. What impact would that have on elected officials?
Dale, it really doesn't impact elected officials at all, and here's why. Under the Fair Labor Standards Act, elected officials are not covered by the overtime laws at all. So these changes that we're talking about on white-collar exemptions and the new salary requirements will not apply to elected officials.
Okay. Charlie, another question that we often get is how can we comply with the Oklahoma statutes that prevent employees from making more than the elected officials and still comply with this new rule?
Well, and this is a little tricky, okay? The federal law, this federal FLSA law that covers overtime or comp time entitlement, that trumps the state law, okay? So what that puts a county in the position of doing with our Oklahoma law that has limitations on salaries, you have to meet the federal law, this new higher salary amount, if you want to keep people that are classified as exempt, if you want to keep them exempt, okay? So it seems to me if you're a county, you have to make a decision. If you've got exempt employees who are below the new higher salary amounts, if you want to keep them exempt, you've got to meet those new salary amounts. The new amounts we talked about effective already in July, and the even higher amount in January. If that means your county officials making less than some of those salaried employees, and you want to keep those salaried employees exempt, you've got to increase your elected officials' salary. The reality is, I think a lot of counties may be in a situation that because they're not going to be able to increase their elected officials' salary, they're going to have to convert those. They're not going to be able to raise the salaries of the employees that are exempt, so they're going to change them. They're going to have to be changed to non-exempt track hours and pay them compensatory time or overtime.
Charlie, another question that we commonly get asked is, every county is required to have an emergency manager and a safety director. Sometimes it's the same person, but statutes lay out what the qualifications and requirements training-wise those employees are required to have. And many counties consider those employees currently as exempt employees and don't pay overtime to them. Do you feel like that position would qualify, number one, as an exempt employee, and then number two, would it be under this requirement as well?
Well, so I think what you're going to find, Dale, is in some counties, those positions are going to satisfy one of the white-collar exemptions. Other counties, they may not. It's going to be really on a county-by-county basis, and it's going to focus on what duties or responsibilities they have. Just as an overview, we were talking about three white-collar exemptions: executive, professional, administrative. If your director, your safety director, or emergency manager does not supervise two or more employees, they likely would not qualify under the executive exemption. If your individual does not have formalized training in an educational program in science or specialized learning, they probably will not be qualified under the professional exemption. Now, if they do office work, non-manual labor, and they exercise independent judgment and discretion on some significant operations of the county, and that certainly may come up in these positions, and they exercise that kind of discretion and judgment with little or no oversight, they've got some discretion there, they may qualify for the administrative exemption, that third white-collar exemption. Keep in mind, there are a couple pieces to this. To really qualify for that overtime exemption, they not only have to meet those duties tests and be paid a salary, they're going to have to be paid these new higher amounts, the $844 a week effective now, July 1, and the over $1,100 a week amount you mentioned effective January 1.
Charlie, another question we get commonly asked, are deputy sheriffs going to be affected by this new minimum weekly requirement?
Okay, and again, that's another example where it may depend a little bit upon the sheriff department with particular county and the size of that department. We've got a federal case many years ago, Nichols v. Hurley, that really found in that particular circumstance, deputy sheriffs that work and interact directly with the sheriff are covered by and considered personal staff under the Fair Labor Standards Act. And if you have that kind of a direct report and direct interaction between a deputy and the sheriff, that personal staff exemption means you as a deputy sheriff are not covered or not entitled to overtime or comp time. Now, if you're with a county that has a larger department and you have more deputies and perhaps you have some intermediate levels of supervision where you have deputy sheriffs reporting to under sheriffs or captains, you may not qualify for that exemption. Now keep in mind, if you're in one of those departments that are larger and you don't qualify for that personal staff exemption because your deputies are perhaps reporting not directly to the sheriff but some intermediate level supervision, then yeah, they're going to have to meet that salary requirement, or otherwise you're going to have to start tracking their hours and paying them overtime or comp time if they work in excess of the minimums.
Charlie, are these new rules, are they hard and fast, cast in stone at this point, or is there a potential for something to change?
Well, Dale, right now there are at least 2 lawsuits, both in Texas, that are challenging whether the Department of Labor could institute these new increases in the salary minimums to keep the exemption. So they're trying to set those aside. I think we're going to get a ruling from one or both of these courts this fall, and on whether or not the Department of Labor can raise those minimum salaries for these exemptions. ACCO and McAfee Taft are following those cases very closely, and I can tell you, as you already know, ACCO will keep you advised on when and if those decisions are reached this fall. So we're monitoring it very closely.
Okay, Charlie, if this rule is not changed in the federal courts, in the meantime, what would you recommend that employers at this point in time do?
Well, they're kind of in a tough spot right now, Dale. So my suggestion is, first of all, audit your practices right now. Identify what employees or what classifications you have working with you as a county that are classified as exempt under one of these white collar exemptions, whether they're classified as executive, professional, or administrative. Look at what jobs you have that you've classified under those white collar exemptions as not being entitled to overtime or comp time. And then when you identify those positions, look at their pay. See if their salary meets the new minimums so they can remain exempt from overtime or comp time. Now, one thing we haven't said, and I hope everybody realizes, these new rules do not affect or change anything for the employees of the county that you're treating as non-exempt already. In other words, the employees that you're paying overtime for or paying comp time for now already and keeping track of the hours, no change, okay? So let's say you're a county, you've done this audit, you've identified the positions that are classified right now as exempt from overtime or comp time, but you've discovered that their salary, their weekly salary, now falls below those no minimums, or may fall below the minimum when it goes over $1,100 in January. What do you do? Okay, so you have you actually have 3 options. The third one's a little risky, okay? Your first option is when you identify a job that meets the duties test and you're classified as exempt from overtime or comp time under one of these 3 white collar exemptions, but your salary is below the new minimums, you can raise the salary and keep them in a position where they're not entitled to overtime or comp time. That's option 1. Option 2, if you're not willing or perhaps unable to meet that new higher salary limit, then you should reclassify them as non-exempt, have them start recording the hours they actually work, and be prepared to pay them overtime or comp time for hours worked in excess of the minimums. The third option is to not do anything. This is the risky one, okay? Not do anything and see how these courts rule. And then if they rule that these new exemption limits are improper, you didn't need to make any changes. If they uphold them, then you better move fast, okay? The reason that third option, I think, Dale, is kind of risky is these new limits went into effect on July 1. So technically, if you go that third option, you're in violation, and it's willful. So that has some pretty significant penalties for employers, counties, if they guessed wrong. So this is kind of thorny. It's hard to navigate this, and please, counties out there, keep in mind ACCO and Dale are a great resource. If you have questions on how you need to navigate these changes, please get a hold of ACCO. Please talk to Dale. He can be a great help, and Dale can also point you to some resources that are available publicly to answer some of your questions. Hope that's helpful.